basis to evade questioning in this kind of confirmation hearing. But I'd like to point out also that this witness has no right to invoke that privilege. It's a privilege for the government of the United States to invoke. Now, I notice that the Deputy Attorney General is sitting right behind the witness. I didn't hear the Deputy Attorney General invoke this privilege on behalf of the government of the United States. And I might point out also that the witness is invoking it selectively. When he wants to answer the question, no privilege. When he wants to avoid answering the question, he says he's not at liberty to answer it. We've never accepted that kind of tactic on the part of a witness. Yes, nominees have sometimes said they can't comment on a case.
Welcome back to American Stronghold, the channel where we cut through the political noise and get straight to the truth that mainstream media won't tell you. Before we dive into today's breakdown, make sure you hit that like button, subscribe to the channel, and share this video so more Americans can hear the facts. Every subscription and share helps us push back against the one-sided narratives coming out of Washington. Now, what we just witnessed in this Senate hearing is another perfect example of how the left weaponizes hearings and confirmation processes to smear nominees who don't fall in line with their agenda. Senator Whitehouse and his allies spent the entire time twisting the idea of deliberative process privilege, something that has been used before by nominees from both parties, into a personal attack.
Or an issue because it may come before them as a judge. But this kind of selective invoking of a privilege smacks of evasion and defiance, and I think reflects on us as a committee if we accept it in this context, Mr. Chairman. So I hope that the witness may be instructed to answer these questions, or we can have a resolution somehow on the legitimacy of this kind of privilege and ask the witness to come back. Let me begin my questioning.
Mr. Chairman, I think the clock was started on Senator Blumenthal while he made his point of order. It might be a courtesy to allow it to be. Thank you. There it is.
I hadn't noticed that, Mr. Chairman, but I thank Senator Whitehouse for pointing it out. Thank you.
Let me say in the future,
Mr. Bove,
White House made very clear the issues you're bringing up, and I said I'm willing to discuss them. But
thank you.
We can't take the time of this committee to hear a repeat of everything from every member that would disagree with what I said in my opening statement.
I appreciate
Senator
your
Bowman.
point, Mr. Chairman. I'll begin my questioning. Mr. Bove, you responded to Senator Kennedy's questions about who was consulted about the dismissal of charges against Mr. Adams. Did you ever talk to Stephen Miller before you filed the memorandum on February 10th ordering the dismissal of the Adams charges?
Senator, I responded to Senator Kennedy's questions based on a publicly filed document that described the Attorney General as a...
Did you talk to Stephen Miller?
I'm not going to describe the participants in conversations.
So you won't answer that question?
No, I will not, Senator.
Why?
Because it is not appropriate for me to discuss...
It is appropriate for you to tell us whom you consulted before taking action on behalf of the United States of America. You have no basis to avoid that question, Mr. Bove.
Respectfully, Senator, I'm answering that question in a manner similar to several nominees before me, including Judge Katz's.
Did you talk to anyone in the White House, including the President, about dismissal of the Adams charges before the February 10th memorandum?
I respectfully refer you back to my answer, Senator.
I am absolutely flabbergasted that you would come before this committee and refuse to tell us basic facts about a case that is at the core of the challenges to the appearance of impropriety that should disqualify you. You have the opportunity to clear the air, to come clean with the American people as well as this committee, and you are evading and avoiding these questions.
Senator, if you have a question about the position that I took in public with respect to the Mayor Adams case, I'm happy to address it, and I've addressed several today.
Well, I have asked you a question that bears on the appearance of impropriety. Let me go on. Mr. Bove, in court, you represented, first, that there was no quid pro quo, but you said that the decision, even if there were a quid pro quo, was unreviewable by the court. Do you stand by that?
I don't think that's what I said, Senator, because it's not consistent with the rule, which explicitly provides.
Well, you said it not only once, but you said it a number of times, and the judge observed, Judge Ho said, that your position was, quote, fundamentally incompatible with the basic promise of equal justice under law. That's what he said about your position, that the decision to dismiss these charges was unreviewable. Do you stand by that assertion?
I never made that assertion, and the judge granted the motion, Senator.
He granted the motion, but he disagreed with your premise that it was unreviewable. Let me ask you, are decisions to dismiss cases, as with that one, unreviewable?
The text of Rule 48 requires, in the instances presented by the Adams case, that dismissal only be provided for with leave of the court. That's as near a quote as I can give you. And the entire brief that I submitted acknowledged that point because we were seeking the leave.
Mr. Bove, I am concerned about the quid pro quo that the judge concluded had been done. In fact, he said everything here smacks of a bargain. Everything here smacks of a bargain. But the quid pro quo that really concerns me is the one that brings you here today. You were virtually the only attorney in the Department of Justice willing to go to court and make a claim that career prosecutors said violated their basic standard of ethics. And the quid pro quo was a nomination to the Court of Appeals. That's the appearance that the American people can take away from your sitting before us with that nomination. And I think it does grave damage to respect for the rule of law, notwithstanding your assertions about your adherence to it, for you to be here as a result of that stand by you. Let me ask you about a separate issue, the firing of prosecutors and investigators who were involved in the January 6th prosecutions. You were involved in purging prosecutors who, in good faith and an exercise of their prosecutorial judgment, they went to court, they brought charges, you purged them. Isn't that correct?
I don't agree with the use of the word purged, Senator.
Well, you fired them.
I authorized the termination of probationary employees at that U.S. Attorney's Office, yes.
Because they prosecuted the January 6th rioters.
No, because I was concerned about efforts in the prior administration to embed those prosecutors.
Instead of focusing on qualifications, experience, or judicial philosophy, they chose to hammer away at selective talking points meant to paint the nominee as corrupt or dishonest. Let's be clear. What Senator Whitehouse is doing here is political theater. He claims the nominee is being evasive, but in reality the nominee was following the same standard practice that countless other nominees, both Republican and Democrat, have followed when asked about internal deliberations. The purpose of these hearings is supposed to be fair evaluation, not an ambush where senators demand private communications that cannot ethically be disclosed. But when a conservative or a Trump-aligned official comes before the committee, suddenly those standards are thrown out the window. Whitehouse pushed hard on whether the nominee spoke to Stephen Miller or President Trump regarding the dismissal of the Adams case. Notice how it was less about the case itself and more about tying the nominee directly to the Trump White House. This is the left's obsession. They want every single decision tied to Trump so they can claim corruption and shout quid pro quo. What's worse, They accuse this man of receiving his nomination to the Court of Appeals as a political reward for a legal position that career prosecutors disagreed with. That is a serious accusation, yet was thrown around casually without evidence, just to create a narrative that undermines the rule of law. The irony here is thick. White House claims to be defending the rule of law, but in reality, he is eroding it by suggesting that only certain political perspectives are acceptable in a courtroom. When a judge like Judge Ho critiques an argument, that's part of the judicial process. But to twist that disagreement into a declaration of unethical behavior is dishonest. The nominee clarified his position, noting that under Rule 48 dismissals still require court approval, which is exactly what the law says. Yet White House ignored that and pressed forward with accusations. What the American people need to see is that this is not about justice, not about ethics, and not about the law. This is about power. The Democrats on this committee cannot stand the idea of a strong, conservative judge being confirmed who might actually follow the Constitution instead of bending it to fit progressive ideology. They're terrified of judges who believe in limited government, equal justice under the law, and accountability. So they invent scandals, smear reputations, and drag good men and women through the mud to prevent them from serving. We have to ask ourselves, what kind of precedent does this set? If every conservative nominee is accused of impropriety, tied to Trump, and painted as unethical simply for doing their job, then the confirmation process itself is broken. It becomes nothing more than a partisan witch hunt. And make no mistake, that hurts America. We need judges who aren't afraid to stand up for the Constitution, not judges who are hand-picked to appease the left's political agenda. This is why we at American Stronghold will continue to shine a light on these hearings. The American people deserve to know the truth. They deserve to see through the smokescreen of partisan attacks and recognize what's really happening: an attempt to silence conservative voices and reshape the courts into activist machines. So if you believe in fairness, if you believe in the Constitution, and if you believe that the rule of law should not be weaponized by partisan politics, then stand with us. Like this video, subscribe to American Stronghold, and share this with your friends and family. The only way we counter these tactics is by staying informed, standing united, and refusing to be silenced. This hearing is just one battle in a much bigger war over the future of our judiciary and our country. We're going to keep watching, keep reporting, and keep fighting for the truth. Because at the end of the day, the American people deserve nothing less.